on the legal entanglements and entitlements relating to cultural property from Sri Lanka's colonial past. And so that's, the topic of discussion today. Before we start the discussion, I just want to briefly explain why CHDM has organized this particular discursive space. So the idea behind the Dutch repatriation series of discursive spaces is to facilitate discussion and discourse about concepts of repatriation, restitution, and on museology as a whole. We feel that the repatriation of objects from the Rijksmuseum last year provides an opportunity for people in Sri Lanka to kind of engage with and explore a range of ideas and to actively participate in, and expand on the global conversation happening on issues of decolonization, on cultural heritage, and on national identity formation. However, we feel that many of these things haven't really been discussed at a wider scale, so this series is kind of an attempt to bridge that gap and start a conversation on some of these complex and globally relevant issues. So when talking about repatriation, I think it's important to recognize that it's a process that is shaped by a host of legal, political, and practical concerns, and very importantly, by existing global structures of power. We feel that understanding the complexities and particularly the limitations of the legal frameworks that shape this process is vital to engaging more deeply with this idea of repatriation as a whole. So with that, I would like to invite Professor Kamardeen to give a short presentation on this topic.
Thank you, Anisha, and good evening, everyone. At the outset, I want to tell you that though I've had a lot of research areas, nothing has challenged everything I learned in law school as much as research I've done in this area. And so for me, it has also been a journey of transformation. To come from a legal background where we focus a lot on certainty, because after all, law must be certain if people are to know their rights and entitlements, to then saying we are questioning this very fundamental basis that we are standing on. And in that questioning process, we try to unravel and uncover several deeper layers, and that this is very new to me. Probably maybe historians and sociologists do it on a much more regular basis. But for a lawyer, legal researcher, this is something very new. So this presentation, there are so many aspects that I like to touch on. So the presentation is trying to draw a lot of things together under a common theme, and perhaps we can discuss all of these at leisure even later on. I want to talk about international law and its impact on post-colonial relationships, because I believe that it has an important bearing not only on the objects that were returned by the Dutch, but on any future return programs that might take place. I also want to talk about justice, because I think a discussion on justice is very important to talk about our entitlements, how we feel, whether we feel hard done by, whether we feel justified, whether we feel satisfied with this return and with future returns that we might have. Then the current efforts at the return of colonial cultural property, of course, focusing a lot on the 6 objects that came from the Netherlands. We also need to talk about the local legal framework, because if not, we really don't have a reference point to look at how are we going to deal with other countries. And then the last one, the question of color and colonial mentalities, which is really the topic that takes me furthest away from my comfort zone, but we'll try to discuss that as well. Now, I state this as a fact, but of course this is up for discussion, and this is a view that is challenged, so I've just put it there as a sentence, but we can always talk about it, that empire building was, of course, almost a mission of every European nation, because the Pope told the European nations, don't fight with each other, you can go and take the rest of the world and carve it out into little pieces, and you can then start exploiting those countries. So then Europe stopped fighting with each other, they started colonizing. And they needed, of course, a body of rules to regulate these new relationships. And these rules, I assert that they remained unquestioned. They form the base of modern international law, and even what we learned in law school were all Anglo-European legal theories coming from the 16th, 17th, 18th centuries. What we learned as sources of law from the Far East were all the fringe areas. They were like the also sources, but the main sources were coming from the Anglo-European tradition. And in Ileana Poras's article, she also talks about how international law of that era made the native the prime focus of its investigation, but sought to exclude the native from rights. So this entire body of law seems to have focused on looking at how we could exploit the native. So the native is very important in international law, but sought to disenfranchise the native at every turn. And even for me, coming across the 12 movement much later in my practice was a real eye-opener, because the third world approaches to international law, for example, question these bases. For example, something that we might take as a given and says, how did it come there? Why did it come there? Who put it there? And then we look at the reasons for it coming there, perhaps very personal reasons, very agenda-setting reasons, reasons that today we would say were conflict of interest. I mean, if I worked for a company and I came and espoused its views, you would tell me I had a conflict of interest. But would you dare to say that to Hugo Grotius, regarded as father of international law? We would see that colonizers fashioned lots of the rules that were used in dealings with natives at the time, like the absolute right to trade. When we talk about the human rights regime, the right to trade came up even before the right to life. And we're talking about this being a base of the modern human rights regime. Freedom of the high seas, as saying, let us, take our ships on the high seas so that we can go everywhere and we can then subjugate you. The right to acquire territory by conquest. We all believe that you couldn't walk into a country without wanting to take it over. But there had been expeditions from the Far East which were very non-invasive, but nobody talks about them. The right to use force, and even the law of price and booty were almost exclusively developed by this regime. And Hugo Grotius himself, even though he did write some very important treaties, in the incident where the Portuguese ship, the Santa Catarina, was basically subject to an act of piracy, and Hugo Grotius was then employed by the Dutch East India Company to defend this position. It of course led to one of his greatest works, but today it's being viewed in the light of Grotius not expounding themes of international law, but rather Grotius looking at how he could defend Dutch interests and legitimize these. But of course this remains to be, this can be heavily debated, this is just my view. Keane himself has noted that certain aspects of Grotius's account of the law of nations have a striking proximity to the practices of colonialism and imperialism that Europeans adopted in the extra-European world. So if we're looking at Grotius as having written the fundamental treatise on the law of war and peace, and we look at now that this has influenced the way we think about international law, then of course the influence is very great. The next point for us to look at international law is of course in the post-World War II era, where we find that the use of force is prohibited, the pacific settlement of disputes is encouraged. So then there is an acknowledgement that everything that happened in the colonial era was wrong. It is wrong to walk into somebody's country and enslave everyone or take away all their objects. But the rule against retrospectivity means that these actions can't be questioned. So it's acknowledged that you can't do it anymore, but it was done and you can't question those because you can't question something that was legal at the time. That then brings me to the next question, the universality or temporality of justice. Is it all right to say we will divide history into little periods and say at certain times this is okay and at certain times that is okay? Does it mean then that justice is not universal? But we do find the universality of justice in concepts like the golden rule, the principle that says I'd like to be treated the way I treat other people. And also if you look across all religions, philosophies and legal systems, there's a prohibition on murder, there's a general prohibition on theft. So we could say that justice is universal, and we must believe it because that is what gives us hope. But in the clash of cultures between the colonizer and the colonized, there are interesting ideas of justice that have emerged. The Buddha stated that there was no such thing as a just war, because he said that either party believes that their cause is just. Justice as temporal is also a concept that has been adopted by the former colonizers, and we see it in a lot of international instruments as well. So for example, the 1970 UNESCO Convention, which is very important to any discussion on cultural property, admits that there could be cultural property belonging to one country that is found in another country prior to 1970. But the convention only applies from 1970. So it says, the trafficking of cultural property is very bad. It is very bad for, the cultural identity of the people. But this is bad only if it happens after 1970. If it's happened before 1970, we're not saying it's bad, but we leave it for bilateral negotiations. And if you have ever entered into a contract with somebody, you would know that there's something called bargaining power. And in contractual relationships and contractual negotiations, if you have a weaker bargaining power, you generally get the worse end of the contract. And that is why international conventions strive to give rights to everyone, regardless of the power balance that they have on the international stage, because we all understand that it is important, it is relevant. It is also the reason why smaller countries like Sri Lanka take part in international negotiations, and we are part of the global system because it helps us even if we are a smaller, economically disadvantaged nation. So if justice is temporal, then let's go back to the colonial era. Is that version of justice the version of the victor? Is that what we're carrying forward now in the 21st century? And our ideas of justice, what we believe is right, because we accepted, when I started doing my research in my very first article, I accepted the fact that the 1970 convention only applies after 1970, and that it had no bearing, and therefore we had no rights relating to cultural property taken during the colonial era. In that article, I also contended that we would just have to resort to requests, just a request that we get our cultural property back. Because probably I was also believing in that particular idea of justice. Coming to the current efforts, and I think this is very important because after a long time we actually saw, that we saw some progress. Prior to the Dutch restitution policy, a few museums in countries like the USA and a few countries in Europe had some unilateral return taking place. But the Netherlands was among the first of the former colonizers to adopt what they called a restitution policy, and I'll talk about that later. Then there was a report called the P. Proce report, and these objects from Sri Lanka were originally not slated to be in the research, but at the last moment, through some good luck, I suppose, these objects were also included. Their provenance was studied again, and based on the findings of the provenance report, these items were returned to Sri Lanka at the end of last year, and you probably may have visited them in the museum and seen how beautiful they are. And also some of them, particularly the wall guns, have contained some aspects of industrial, of actually patentable aspects which were lost to this country, and then subsequently the patent for the screw mechanism was taken out by somebody, a US national in the 19th century. In the 18th century, but this was there from 17th century in Sri Lanka. So that's also an interesting point. Then coming to this term, return or restitution, because everyone talked about restitution. The Dutch also talked about a restitution policy. But this is one thing that as a lawyer I am against, or I find to be not proper, because the word restitution in international law as given to us by the Anglo-European tradition, is something that follows a finding of an internationally wrongful act, which is imputable to a state, which has caused damage, and for which reparation, which often involves restitution, must be made. So therefore, a unilateral policy by someone to return an object, to me, doesn't qualify as restitution, because when we say restitution, it assumes that all of this has been done. But was wrongdoing ever acknowledged? Was it ever imputed? I don't think so. Looking at the local framework on cultural property, I don't think that Sri Lanka has also done as much as it could have, because the Antiquities Ordinance is a pre-independence piece of legislation, and it defines an antiquity as any object, so on and so forth, found in Sri Lanka. which means cultural property that is found in other countries by 1940 was excluded from the definition of antiquity. The 1988 Cultural Property Act also doesn't make any mention of cultural property originating in Sri Lanka but found in other countries. This is probably based on the ideology of territoriality, which is one of the bases for jurisdiction in international law, which again we seem to have imported lock, stock and barrel and taken as the base of what we would now use as the reference point. So ownership then, or the nationalist ideology of cultural property has been given second place to the territorial concept. But that is very unfavorable to Sri Lanka, because by the time these pieces of legislation come into being, most of the cultural property of the colonial era has already found its way out of the country. So then when you apply the territorial concept, you cannot extend it. Of course, we know extraterritoriality in international law is not always a very good thing. But in this particular concept, where it has been, or it can be proven through provenance research that the object originates in this particular country, it is very unfavorable when you don't even have recourse to the nationality jurisdiction. So coming to the last topic that I have to talk about is the question of color and colonial mentalities. And in the course of my research, I found, to my dismay, that cultural property has, well, this is not to my dismay, but the second part. Cultural property has been given special treatment compared to other types of property and loot or spoils of war. So firstly, the development of the principle of military necessity. That caused the victors in battle to respect property that was not actually used in warfare. So then military necessity says, right, you don't have to destroy everything, you can respect some of these things. Secondly, the influence of the Renaissance brought with it a new respect and appreciation for art and culture, and then that extended to the protection of works manifesting these. This is seen in several treaties, especially following World War I. Ironically though, it is to be noted that this respect is afforded only to property belonging to European nations. So that by a certain time period, European nations afford this respect to each other's cultural property. So they don't destroy it, they don't take it away, they don't deface it, they don't do things like this. But while they kept respecting the cultural property of their European counterparts, they didn't extend that same respect to cultural property, maybe from their colonies or from other countries. So why is this? There's only one exception to it, and that is the treatment of cultural property from Greece, I suppose because it is very exclusive, very expensive, very desirable. That's the only exception that I have found. But apart from that, this continues. And so my question is then, like people have color, does cultural property also have color? Is it important whether it's white or brown or black? So if you say if it's brown property, is it okay to treat it badly? Is it okay to take it away from its country of origin, even if you have nothing to do with it? Like the statue of Tara, which was taken away from Sri Lanka, but which was locked up in a basement cellar of the British Museum for several years, because it was deemed to be too indecent by Victorian standards. It was to them a topless woman. So it was not even exhibited for several decades. So, or the other question is it because our property is not important because we were regarded as uncivilized countries? So that cultural property is important only if it comes from a civilized country. And it is sad that this mentality has also found its way into certain relationships between the former colonized and former colonizers in relation to agenda setting and decision making, which now I think is important because institutions like CHDM are doing work, places like University of Colombo, California, we are doing work, we are engaging in collaborative relationships, but we don't seem to be able to shake off our colonial mentality either. Another point that I want to highlight is that the 6 objects that were at the Rights Museum were consistently labeled as being war booty. even though by the definition of the term war booty, which was developed by Anglo-European jurists, all of them failed the test, because none of them were found in the battlefield, were relevant to the battle at all, unless you can say that the battle is taken to the palace. But a few weeks prior to their return, it was changed to reflect that they originated in Sri Lanka and were on long-term loan, which was also not true, because a long-term loan would then imply that there was some sort of remuneration being paid, and that was also not true. So I suppose this is our fault, because nobody questioned the wrongfulness of this labeling. I suppose we were also happy to have the objects back, even though this impacts on any possible legal and economic consequences. So right now I'm writing a research paper on it, on the fact that if the term war booty was incorrectly applied, that there should be consequences to that as well. But if we don't raise it, if you're quite okay with the fact that it was wrongly labeled as war booty, and we say, yes, that's very fluid and now you can term it what you like, then we give up those rights that we may have to claim in the future as well. And the last point I want to raise is something that I observed on my visit to the Rights Museum in 2022. This particular ebony and ivory cradle, which is here in De Silva's catalogue, which is also a very rare book. I have brought it today. If any of you want to look at it, you can. This was listed in 1970 by the former director of museums, Dr. De Silva, when he looked into the provenance of the objects from Sri Lanka that were in foreign museums. And at that time, with the collaboration of the Rights Museum, De Silva listed that this particular ebony and ivory cradle originated in Sri Lanka, and it is recorded in this book. By 2022, when I went to the Rights Museum, the cradle was listed as having originated in India. So this is verified provenance, and provenance is very difficult to establish in colonial cultural objects, because some of them have been just taken out without proper records. But so my question is, if such a mistake can be made in the face of verified provenance, then what hope remains for objects where the provenance is not clear, the provenance is not established, or where, as we know, in the colonial era, history was often written by the victor. So these are lots of, I think I may have left you with more questions than answers, but I think that's a good place for us to start. So thank you very much.
Okay, thank you, Professor Kamardeen. I feel like that was very, very interesting. So based on that, I do have a few questions, and then we can discuss and then open it up to audience questions. So one thing that you kind of ended on that really stands out to me is in the topic of repatriation is this idea, the large role of provenance. Because as you said, provenance is very difficult to establish, especially in the context of how many of these objects were taken. But it feels like the burden of proof is all in this, by necessitating provenance research, it feels like the burden of proof is always placed on the countries that request the objects to be returned and not on the countries that took the objects in the first place. So can you talk a little bit more about the underlying assumptions and biases that make this the case, and how does that tie into the legal frameworks?
Yeah, that's a very interesting question. I think it comes from this legal point that he who asserts must prove. So then we gain independence. So the legal thing is, if you assert, you must prove. And none of the former colonizers were going to admit that this was taken wrongfully, because as Buddha said, everybody believes their cause is just. So then if you take a hypothetical, so you wake up from being colonized and you have now got independence and you have now got some legal standing and capability, and you say, hey, this is my object. So you assert it. So then the colonizer says, then prove it. Where do you start? And that is why I say that for colonial cultural objects, we must have a separate regime. We must have a standard of proof that is not as high as you would demand from a country that was equal in the taking. Because now there is smuggling, there is theft. But today we would say the two countries, the country of origin and the country where it ended up, have more or less equal standing. So you can approach this examination on a more equal footing. But when the object has been taken in an era where de facto and de jure you were not in power, you didn't have access, I mean, you didn't have even control even of your own archives. It is then very unfair to say, if you assert, you must prove, if as the colonizer you did not even bother to maintain the records that would help this country to do it. Let me take one example. When these 6 objects were being provenant, the research was being done, one of the key elements was the fact that some of the decorations that were on this canon, the Leucase canon, corresponded with wall paintings in Colonia. So the same kind of figurines, the same kind of structures. And that helped to establish that this particular canon was worked here. That immediately led me to think, if we didn't have wall paintings in Colonia, then how would we have established? So the art historian approach to provenance research is also not foolproof. It's also maybe, it depends a little bit on luck.
Yeah. Yeah. It's how do you go about kind of making that more equal though in that case? When you say establishing a separate regime with different standards, how would you suggest, what would the standards be then? Do you have any thoughts on that? I know that's a larger question and a larger debate.
Yes, because if we look at even colonial cultural property, you have a category of objects that are not contested. That are not contested by anyone. For example, no other country was contesting Leucase canon. India didn't bring a claim, Indonesia didn't bring a claim. So when it's not contested, I believe you mustn't waste so many resources and so much time on it, because that is also something that's going to deter developing countries. If someone asked us to finance that provenance research, we couldn't have done it because we couldn't have afforded it. And we're looking at a context where we are basically coming out of economic recession. Even for us to sit here and talk about this, it's a luxury. There are people probably who like to be involved in this, but who can't do it. So at least in relation to those objects where there is no contesting claim from another country, then the provenance research that has been done so far, the listing should have been sufficient, because consistently at least those 6 objects were consistently listed as having originated in Sri Lanka. So as a start, I'm suggesting that the non-contested objects don't have to go through an extremely rigorous process. But where, for example, state succession has now resulted in 2 nations, or there are tribes in a particular country that are also claiming, of course those objects may need to go through some more rigorous methodology of provenance research.
So in terms of you talked about Sri Lanka's legal frameworks, and you pointed that they're lacking. So what kinds of policies do you think Sri Lanka should be developing? Because I know that in some countries they have their own internal policies, like for example in France I know that legally all property of a museum is considered to belong to the public, and therefore legally the French cannot return objects to their countries of origin, because it is considered giving away the property of the people. So they have their own internal frameworks like that kind of contest international frameworks. Can Sri Lanka do something like that? What kinds of frameworks do you think Sri Lanka needs to put in place to be able to give us a good starting point for this?
Yeah, well, I think our legislation is very conservative, so we try to, because of course there is a principle that a piece of domestic legislation cannot be used to excuse yourself from international obligations, which means if you had an international obligation, like let's say you have said we are going to, arrest all hijackers. You can't turn around and say, I don't have a domestic law, so which happened in my airspace, I just can't do it. You can't do that. But France did it. And Britain did it. The British Museums Act, which was passed in 1963, says that nothing in the British Museum will be returned. Which means even if international law or any bilateral relationship or negotiation results in a finding that this object must be returned from the British Museum will use its act to say, I'm not going to do it. But Sri Lanka then follows a policy where we say we are going to stick to the principle of territoriality. We don't even assert the fact that objects lost during, involuntarily lost during the colonial era belong to Sri Lanka. And even in De Silva's catalogue, because De Silva is a historian and not, I don't think in this current political climate, the state could do something like that. So there are a lot of questions.
Yeah, so speaking of constraints, with these existing frameworks of law that are, as you said, built on kind of problematic histories and histories of structures of power, why do you think that changing these laws is so difficult? And what is a good place to start? Like, I know you mentioned TWAIL and their work, but yeah, how can people get involved? What's a good place to start?
Yeah, so I think we can also have the the top-down approach. We can, if international law was also to challenge some of its existing ideologies, then people would become more receptive to the fact that these concepts are not written in stone. And so we have researchers from now we call it the global south, the global majority. The global majority now, right? They're coming up with these ideas. Then it might help certain ideas to be changed. Then we also have the bottom-up approach, where I believe even if it's difficult, we must engage in some sort of at least dialogue like this, which could lead to some form of lobbying, which might result in some form of law reform, at least to mention, because right now we haven't mentioned in any piece of legislation anything about colonial cultural property. We haven't even talked about it. We haven't even acknowledged that it's there, or that it was a problem, or that it left our shores. So I think both of these approaches will help, because I believe that is what has even spearheaded this current effort. Even things that we don't think are connected, like when Black Lives Matter happened, I felt that it was also one of the reactions to some of these colonial injustices. And that so each of these movements, these events, can have a bearing on changing this existing ideology, because I believe it has been so much ingrained in our collective minds. This is set in stone, it can't be changed, this is the idea that it is. But TWAILers were brave enough to come up with it. I mean, when none of us questioned, when we said, yes, Grotius did this and this is what, the TWAILers were brave enough to question those structures and say, so who said it, who put it there, why was it done? To go back and look at the fact that some of those ideologies were also created for personal interest and not really with justice as universal concept. So I believe that both the approaches must happen. I mean, there must be some sort of domestic law reform also.
Yeah. So yeah, you talked about this kind of unchanging ideology, and I feel like that you see it all the time in people's mindsets, this kind of acceptance of colonial norms and colonial ideas. Like, I also see it in sometimes in debates about repatriation, where people say, oh well, we can't look after these objects well, because if they come here, we don't have the resources, or they'll get stolen. But the British Museum had a major theft recently. There's lots of reports about how major museums in a lot of the West don't have the capacity to look after the millions of objects in their collections, and oftentimes they are kept in storage centers, storage facilities that are not secure, not even guarded against the elements. So people never look at those things because this mindset exists, like, oh, we don't have the capacity to look after. So can you talk about your experience doing research and looking at this, and your experience of this colonial mentality and how it affected your experience?
Yes, so it's a dangerous road to go down. I mean, I also understand the fact that yes, you need some resources, and especially now if we take the 6 objects, they were taken away from Kandy, which was probably 5 centigrade cooler in 200 years ago, and now brought back to Colombo. But if you perpetuate that ideology, it gives an incentive for countries to weaken you, so that you will permanently have no capacity, and then say you have no capacity, so we are not going to return objects. So I think they are two related, slightly related, but two different concepts. Because now the logistical issue is one, yes, it has to be tackled, but more important is the ideological issue. Was it yours? Do you deserve to have it back? and should it be brought back to your country? The should it be brought back to your country argument, I would have as a researcher, and this is what I also, I have said in the spaces that I've spoken, I would have said that there is a process and that the return would have been the last step in that process, but that we omitted some of the important previous steps. For example, did we talk about the legal basis for this return? We didn't, because it was unilateral. The Dutch decided to return, the Dutch returned. What did Sri Lanka do? We instituted a restitution committee which responded at every stage. It didn't take any overt steps. We didn't talk about the fact that if it was being returned now, why was it being returned? Because it was wrong suddenly in 2022, or it was wrong in 1796? Because if it was wrong from 1796, then shouldn't we have had some compensation for those 200 odd years, right? So we didn't talk about that. If it was on long-term loan, we didn't talk about what were those conditions. So why are we getting it back in the first place? Is it like, if is it this mentality we would take a headache even if it was free, right? Why did we take it back? So we said, yes, we asked for it. But I would have said there should have been some legal statement, because that would have been informative for our other dealings, for other objects, with other countries. Because right now, the Dutch restitution policy also said it was only a moral duty to return, that there was no legal duty, and that is firmly written in the Dutch restitution policy, only a moral duty to return. Which means they also cleverly skirted the issue, and we didn't see it coming. Because we have not had anyone advising the government from a legal standpoint. Everyone who was involved in the PPROSEC project was only invited because they were art historians, because that was the only capacity, the only role they played, because that's the only research they did. Nothing was done in terms of legal research to establish these findings. That I see is a big problem.
Do you know, so when they returned objects to us, as you said, it was kind of almost a happy accident. And I know it was part of returning objects to Indonesia, that like most of the objects returned, it was 6 objects came to us and something like 500 or 600 objects went back to Indonesia. Do you know if they made a legal statement about the return, and if so, what it was? Because that's just a question.
Yes, well, that is something I do admit that I haven't looked at,
yeah, I
and I think it's a good place to start. It's a good place to look at whether they also talked about legal entitlement. But I do know that in some, especially in the World Museum, there were sections that I looked at where the objects were from some countries listed as being on loan. So they are now paying some of those countries for the privilege of keeping those objects with the museum. So those mechanisms they are not uncommon.
So actually on that topic, you kind of used to talk about the temporality of justice, the rule against retrospectivity, and going that we don't know what Indonesia said. Are there examples of any examples of more recently enacted laws where they sort of recognize harm in the past and then enact a law to kind of prevent it happening in the future that do apply retrospectively, not necessarily about cultural property, because obviously the cultural property is laws of the UNESCO Act, and there's another one. Yes.
UNESCO, yeah, and that's UNIDRA.
Yes, but are there any other laws that have been instituted retrospectively for actions taken during the colonial period? Like, is that precedent to say this justice should apply retroactively?
The only area that I can really think about is probably human rights jurisprudence, but I'm not an expert in that area, so if you, I would have to also research into it to speak very definitively about that sort of thing.
Okay, it's interesting. Can you talk about your personal experience doing this research, and if you've had any experiences working with people, with museums, with on these topics?
Yes. So when I was, it was somewhere in 2019, when the Dutch were originally, they were thinking about, they hadn't drafted the restitution policy yet, but the Rights Museum was doing some research on these objects itself. I think they had an idea that they wanted to return it, but they were prevented, or they had been asked not to reveal that to researchers. And someone contacted me and said, we are doing this research, and would you, we might, they didn't say we might return it, but of course, probably that is what I understood. And I had some interactions with museum staff from the Rights Museum. And it was a really trying time, because I met this person the day after the Easter bombings, and it was a very volatile situation in Colombo. The university was closed, but I went for this meeting because I was so interested in the fact that the objects might come back. And in the course of the discussion, and also I had done some research, I had unearthed some very rare documents from the archives the week before, and I had already shared it. And then she turned around and said, well, if this is all, then you really can't prove that the object is yours. And that statement really took me by surprise, because I had never thought of it in that way. I had never thought, is someone on a fact-finding mission to find out whether Sri Lanka has a strong enough claim? Perhaps that was not the reason, and at the end of the day, the objects were returned. But I realized that this question of access also, this is a very strange thing. I mean, researchers come from the Netherlands, they can meet the minister. But I am a researcher in Sri Lanka, and I can't meet the minister for 6 months, even if I ask for an appointment. And nobody in Sri Lanka can meet the Dutch Minister of Culture and Heritage. So there's a huge imbalance in terms of access, even to governmental records, which I find consistently, you might find too. Researchers in Sri Lanka find it so difficult to access records. They find it so difficult to access people. They find it so difficult to access committees and talk to them. But if you are a researcher with white skin and you walk into this country, no matter who you are, you can meet the minister, you can meet the director of museums, you can meet the people on the restitution committee, and in fact, I get most of my information from them. White researchers who come to Sri Lanka, who meet all these people, and then who tell me what's going on in my country. And that, I think, is one of the worst places to be in. To be brown. In a brown country.
Why do you think it is that the Dutch have undertaken this restitution process, as they call it? Because, as you said, they are the only country so far to have taken this kind of large-scale action. To a certain degree, I think that is commendable. Do I have to say that? But no, I genuinely do think that it is commendable. But do you think it is a one-off? Do you think it is a sign of things to come from other countries? And why do you, and obviously cultural diplomacy is a big part of that. But, why is it that the Dutch have then latched onto this cultural diplomacy and no one else?
The answer to that may be looked at what you think about it. I mean, if you come from an altruistic perspective and you look at even in Dutch society, the younger members of Dutch society find it very abhorrent to walk into museums and say something like, this was conquered from here, and this was looted from here, and this was taken from here. So there's been a push from the young people in Netherlands also to get rid of these things, because they find it very uncomfortable to walk into a museum and look at that. That's one aspect. But if I was to be very suspicious, and this is the suspicious me that is coming in, I might say there's a global movement now, right? Cultural property, especially after the Black Lives Matter, we find is the last tangible piece of evidence of a very cruel colonial era, because the slaves are not there anymore. The money has been converted, right? If you look at the atrocities of the colonial era, and if someone wanted to revisit that and talk about, let's pay compensation for one slave, how much? Can you value it? Then how would you pay compensation for 1 million slaves? But colonial cultural objects are a tangible reminder of this very cruel past. And as long as you keep them in your country, you are opening the door for former colonized to come and say, you also did other things. And research is now taking place on those levels, looking at how many slaves were taken, how many people were killed, how much of merchandise was taken away, the wealth of these countries. And if I was a Dutch policymaker, I would say, get rid of the tangible evidence. right? But get rid of it, saying you only had a moral duty. I mean, that's what I would advise. So, you can think what you like.
Yeah.
Because colonialism is a can of worms now. I mean, with these countries in East Asia, the former colonized now becoming economically powerful, I believe that this discussion is going to explode. And when it does, I don't think that even the wealth of Europe is enough to compensate for the past.
How do we kind of jump in on that? How can we as like individuals and civil society organizations here in Sri Lanka, but also everywhere in the global south or whatever you want to call it, how can we advocate for ourselves for a more critical approach to legal frameworks? Do you have any takeaways from this? Any advice?
Yeah, I think firstly we have to get rid of the colonial mentality in ourselves. Even in this interaction that I had with the Dutch, I have always been a very differential partner in research. And I think that is probably, I really don't know, probably we are all suffering from this colonial mentality. And we saw it also in this return of the objects. You know, people like, we should be so grateful that the objects were well looked after. Yes, of course, it's a good thing that objects were well looked up. It would be very sad if they came in pieces. But the mentality has to be broken. We have to, do we feel that we are entitled to this property? Do we feel that the Dutch did us a favor by giving it? Do we feel grateful? Or do we feel entitled? That's also a way to look at it. The second thing is that I think in the global south, we tend to be very compartmentalized in our research. We want to be very territorial. It also probably comes with a lack of resources. You know, people don't like to share research projects because they want to, utilize a grant for themselves, because this is all legal research jargon. But I think forming those more open networks is a good thing, because I think even for me, combining legal with some art history, with other kinds of approaches, which we are hoping to do in a project. Zumindu is here. Hopefully, if we get the grant, we'll do it. It will be our first also multidisciplinary kind of thing, where we're also collaborating with others, because I think in this area you need it. You can't only do a strict legal research, and I don't think you should only do a strict art history research, because art historians would say, yes, you have a moral duty, give it back, but they're not going to say what are the legal ramifications. So, that kind of thing, I think it should do. But most importantly, I think we must shake off this colonial mentality.
Yeah. I think it's really interesting that you say this, do we feel grateful or do we feel entitled? And I think I kind of feel both in a way, because I think that there's also a somewhat practical aspect to this, right? I don't think this is why people aren't necessarily pushing back and why the restitution committee here didn't really do anything. But I feel like to a large extent people feel, because of the existing power structures, that we kind of just have to take what we can get, and pushing for more and agitating might then lead to us not getting anything. And so there's this kind of practical aspect of, yes, like to a certain degree, we do kind of have to feel grateful that they are, with all of the power that they hold, there's nothing making them return it. The fact that they are is something that I'm grateful for, but I also feel like entitled to those objects. They are ours. But the fact, like, grateful that they exist in the world structure of power that they exist in, and they are still returning what is entitled to us. I don't know, it feels like it's kind of hard to walk that line, both in terms of how you feel about it and the actions you take, I think.
Yeah, well, I don't think that there was any impetus from Sri Lanka to get these objects back. The push came from elsewhere. So that is something we also could explore if we collaborate with researchers in those countries, and we create that lobby elsewhere that would put pressure on those governments, because us pressurizing Sri Lankan government is not going to help. Especially at this time, where we are placed. I mean, everything is geopolitical.
Yeah, I think that makes sense. That's kind of all the things that I was thinking of, but maybe we can now open up the flow for questions. I think we're going to stop the recording here so that people can feel free to talk and say what they want and ask any questions without.
They won't record it and then interrogate you.